and happy Sunday. I'm Catherine Loftus. This is Note My Objection. And tonight we're going to talk about the case of Brian Walshe. And the case of Brian Walshe begins tomorrow on the first day of trial in Norfolk County Superior Court in Dedham, Massachusetts. Now, for those of you who followed the Karen Reed case, that might sound familiar. It's the very same courthouse, prosecuted by the very same district attorney's office. But despite having some similarities, not only in location and the charging prosecutor, as well as the now infamous Trooper Michael Proctor of the Massachusetts State Police, these cases are pretty different. And so I thought we'd kind of go into a little bit about what has happened, what the allegations are, what to expect moving forward, where you can find coverage over the next couple of weeks on this trial, and that's it. So for those of you who are new here, my name, again, is Catherine Loftus. I'm a former prosecutor. I worked in the Suffolk County District Attorney's Office for just shy of 10 years, and I have been practicing criminally and civilly with my father, Doc, as we like to call him, the better Loftus of the two. For about 7 or 8 years. And what I try to do here is just sort of explain the law in a way that is easy and digestible, because if anybody knows, it's me, that the law is complicated and can sometimes be difficult to understand. So that's what we're doing here today. Brian Walshe, set to begin trial tomorrow. Originally, he was charged with 3 counts, and there was sort of a surprising turn of events that happened just on the eve of picking a jury in this case, which happened before Thanksgiving. But if we go back a little bit, essentially what happened was Mr. Walshe was charged with the homicide death of his wife. In Massachusetts Superior Court, the general track to get to trial is usually somewhere between 2 to 3 years. So this case is, moving along as it generally would be. However, there were some things that came up in the interim, mostly as a result of the Karen Reed case. So for those of you who recall, or if you didn't follow it, in the Karen Reed case, there were text messages discovered by one of the lead investigators, Trooper Michael Proctor. And Michael Proctor was assigned to the Norfolk County District Attorney's office, as essentially they have the state police, and each county has specialized units. And he was in the homicide unit. So not only was Michael Proctor one of the lead investigators in the Karen Reed case, he also was one of the lead investigators in the Brian Walshe case and a number of others. During the Karen Reed litigation, it came to the party's attention, everyone's attention at some point, that Michael Proctor had been not only speaking about the case to people that he shouldn't have been speaking about it, but also that he was speaking about Karen Reed in a pretty disgusting manner pretty early on. Basically, the day that this happened, the John O'Keefe death occurred, which was on January 29th of 2022. I mean, within hours, he's speaking poorly of her, and in a way that should, it just disgusts me as an attorney and as a woman that any officer would be speaking like that about someone who, has rights themselves. So as a result of that discovery, there has been subsequent litigation in Massachusetts, mainly in Norfolk County Superior Court, because that's where all of his cases are. So I think there's 18 or 19, don't quote me on that, different criminal cases that involve Michael Proctor and potentially problematic text messages, investigation, lack of investigation. So while the Karen Reed trial was ongoing, a number of these other defendants, by and through their attorneys, brought this to the court's attention. They essentially wanted to obtain the text messages and the discovery from the Karen Reed case, specifically relative to Michael Proctor, the federal materials for those who remember, the federal grand jury that investigated the investigation of the Karen Reed case. And so there was a lot of litigation that sort of delayed the trial a little bit. Essentially, how it appears to me is that Michael Proctor has a lot of problems, and not just in the Karen Reed case. And I think some of his behavior is likely to affect some of the criminal cases he handled in Norfolk County. But I don't think that's going to happen in everything. As it always has been my position in the Reed case, a lot of things could happen at the same time. Just like, you can have, a police officer who behaves and acts in this manner, and you can still have culpability for a defendant. However, it's the attorney's job, which is Kelly Porges and Larry Tipton. They're very highly respected attorneys here in Massachusetts. They do serious homicide cases. It's their job to make sure, hey, if there is anything in there that Michael Proctor said that could help my client, we want it. So they litigated that. There was a delay. They got everything that they needed. The Norfolk County District Attorney's Office turned it over. There was subsequent litigation in federal court about what could be provided to various attorneys. And it appears that there are text messages or other discovery relative to Brian Walshe. How much of an effect that's going to be, we don't know yet, because we have not heard, if or what he said relative to the Walshe case, whether it's about Ana, whether it's about Brian, whether, we don't really have any idea, aside from the fact that discovery was turned over from the Commonwealth to Brian Walshe's attorneys. So originally, it was scheduled for trial in October, and that got pushed because after everything was resolved with the Proctor issues, Judge Fournier basically was like, we're going to trial, let's go, we're on the track, we have everything else taken care of, let's get there. There was a motion, I think it was within the week before trial, maybe 2 weeks before trial was scheduled to begin in October. The defense filed a motion for Brian Walshe to be evaluated for mental competency to stand trial. And so basically that means that maybe your attorney is concerned about your mental health, whether you're able to understand, whether you're able to actively participate, because you have a right to do that. You have a right to participate in your defense. And so he had been stabbed about a week or two, or maybe a month before, at the Norfolk County House of Corrections, where he's being held. And essentially what Attorney Porges and Attorney Tipton said in their motion is, he is suffering sort of PTSD, and we are concerned about his mental health, and we want him evaluated. So he was sent for an evaluation. That's 30 days. And the trial was continued at that point. When we came back into court at the end of October, early November, Judge Fournier received the report from the evaluation, which essentially said he was fit to stand trial. And so that's where we are today. So we start trial tomorrow. Now, originally, Brian Walshe was charged with 3 counts: first-degree murder, misleading a police investigation, and disinterring of a body. Now, first-degree murder carries life in prison without parole. Disinterring a body carries 3 years in state prison, or in the alternative, 2 years house of correction sentence. Now, these are maximums. That's anywhere. That means that you can't get any more than 3 years in the state prison, or any more than 2.5 years if you're going to do a house of correction sentence. You can do anywhere in between 0 to 3, 0 to 2.5. On the misleading the police investigation, he's actually facing up to 20 years. Excuse me. And that's because on misleading a police investigation falls under the witness intimidation statute in Massachusetts, which is very broad. It's the statute which Aiden County is being charged under with witness intimidation. And essentially, for each charge, if the underlying charge on which you are either misleading the police or intimidating a witness, if that can carry a life in prison sentence, then the potential sentence on the misleading is 20 years. If it just carries a regular sentence, it's up to 10 years. So in general, on a witness intimidation or misleading the police, the maximum you can get is 10 years, unless it's a case that carries a charge that carries life in prison, which is homicide. It's the same here. So he's looking at up to 20 years on the misleading the police, or 2.5 years in the house of correction. So house of correction sentence is different than a state prison sentence, and a judge can give either one. That basically means that the judge has the option to impose a house of correction sentence, which is jail, as we colloquially refer to it, or a state prison sentence. So just before jury impanelment started a couple of weeks ago, Brian Walshe decided to change his plea on 2 of the 3 counts. And the 2 counts that he pled guilty to were the misleading the police and disinterring the body. So he basically admitted to disposing of his wife, Ana Walshe's body. And a lot of people are confused by that. Like, wait a second. How could he say he's not guilty and try to convince the jury he's not guilty of homicide, but then he's admitting to chopping up his wife's body and getting rid of it? Like, how can both things be true? And it's a strategy. It's basically a legal strategy, right? Because what they're essentially doing, the defense, is they're sort of taking away some of the evidence that might be presented towards the misleading the police and the disinterring the body. Not all of it, because I still think that most of the evidence, a lot of people were asking the question, does this mean that they can't tell the jury, that the Commonwealth can't tell the jury that they think he chopped up her body and that he got rid of her in all these different places? And the answer, in my opinion, is no, because I think it still goes to the underlying charge of murder. I think, if you imagine a world where he was only charged with murder and not with disinterring a body or not with misleading the police, that kind of evidence would still come in because it's relevant to prove whether he did in fact kill his wife. So the night before he pleads guilty to both, the Commonwealth was essentially objecting what their position was per the defense report, that they didn't want to negotiate on any plea unless it involved a murder. So, potentially if he had agreed to a second degree, now that carries life in prison with the possibility of parole. So first degree, you have no possibility of parole. Second degree, you do have the possibility of parole. And oftentimes, in a negotiation, you might plea it down from a first to a second, or from a second to a voluntary manslaughter. That's the sort of the tiers of charges. And the Commonwealth's position was, listen, hey, we are not going to play ball unless you're going to talk about the homicide. And if not, let's just go to trial. So a defendant always has a right to change their plea. So they went before the judge and she took the plea. She didn't sentence him. So he has pled guilty. Those charges are off the table now, right? So the only charge that's going to trial tomorrow is the first degree murder. She didn't sentence him on the two in which he pled to, likely because if he is found guilty, she'll run them all together. If he's not found guilty, then that probably, factors into whether she gives him the low end or the high end on the misleading or the disinterring. So he's still looking at, even if he was found not guilty of the homicide, which I think is very, 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 very unlikely, he's still looking at a maximum possible 20 years in the state prison on the lying to the police. So what we're going to see tomorrow is this. We're going to see the opening statements of the Commonwealth, and they're essentially going to present, what they believe are the chain of events that occurred, that Brian Walshe was, getting frustrated with the relationship. There were problems. Ana wasn't living at home all the time. She was in D.C. Maybe they got into a fight. The difficult part for the Commonwealth here is that we don't know what happened, right? Did he plan to do it? That's what they want to show. They want to show he planned to do this. He intended to do it. He had the thought in his mind. He thought she was cheating. His mother was hiring private investigators to potentially follow her. That he sort of was already, in this kind of mindset of things aren't going well. But we don't know what happened. We don't know. And there's no evidence unless he gets on the stand and tells us what happened that night. We don't know what happened. We don't know, did he intend to do it? We don't know how and which way he did it. We don't know if they were drunk and she tripped and fell down the stairs and then he freaked out. And I think that's going to be the difficulty for the Commonwealth, is not that they're going to get in my opinion, it's a very, very high likelihood that he'll be found guilty in her death and held responsible for her death. The question is whether can you get to first degree without really knowing or even have a theory about what happened? Because even if you have a theory, we think this might have happened, it's likely not supported by a ton of evidence, because there's a window in time where, hey, there's two people and one of them is not alive. So, it's very similar to the Karen Reed case. And this happens in a lot of cases. It's like, okay, there's a window of time where we don't know what happens. And the Commonwealth's job is to try to piece those, I was always taught in the DA's office when I was first a prosecutor, brick is not a wall, right? So it's like brick, 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 brick. That's how they think they're going to get to the first degree. I expect in the defense's opening statements, you're probably going to hear some sort of argument relative to, you can't trust the police, you can't trust the investigation, the lead prosecutor prosecutor has been fired from his job on another case, basically for being dishonest, for talking about witnesses in a certain way. That the Commonwealth essentially completely distanced themselves from him as soon as, all that information came out. And so therefore, you, the jury, should not trust anything the Commonwealth says. Do I think this is a persuasive argument? I don't in this case because given the circumstances, there's two people in a house, one comes out alive and one comes out dead. And so I think it's difficult to make the pitch that like, hey, all this evidence is in front of you, but like we have terrible police here, so you should just ignore all of it and like let the guy go. I think there is a chance. I talked about this a little bit in the Ingolf Turk case, in which he was a surgeon who was convicted of killing his wife. And I want to get this right because when I originally talked about it, I thought it was a first degree that went down to a second degree, but it was a second degree, and he was found guilty of voluntary manslaughter. And attorney Kevin Reddington, who's very well respected around here in Massachusetts, represented him, and he had him do the really, really, really unusual step of taking the stand himself. And essentially what he did was he presented an alternate explanation as to what happened. And that's the only way I really see Brian Walshe getting any sort of like actual reduction in the charges that he has against him, a second degree or a voluntary manslaughter, because otherwise, like I said, you have two people in the house and one comes out alive, one comes out dead, and one is on tape going to Home Depot, buying all the supplies, lying to the police, doesn't look great. I think the only thing he can do is get up on the stand and say like, hey, it was we were drunk, we were fighting, it was an accident, she fell down the stairs, she broke her neck, I freaked out, I didn't know what to do, and then I don't know why I did it, but I did it, and it is what it is. So again, do I think that's going to be persuasive? No. Do I think he's going to take the stand? Probably not. But I do think it's an interesting consideration, because when it comes to these kinds of cases where the only other explainable, the only other thing that makes sense can come from the other person who was there, you run the risk. I mean, nobody ever wants to put a criminal defendant on the stand, never mind one that has lied to the police, admitted to chopping up his wife, has been convicted in federal court of forgery, of fraud, you know what I mean? So someone who's not known to be honest. So I think the likelihood of him getting on the stand is probably pretty slim to none. But I do think that, it's an interesting, we used to have this kind of idea of like, oh, no body, no case. The other stuff, they say no face, no case. That's what all the defendants say. No face, no case, no face, no case. It's true. If you don't show up, there is no case. But that's an aside. I think that, it used to be like, oh, there's no body, how are we going to prove it? But now we live in a world where we're under constant surveillance. Like, we're not talking about 1985, where like, oh, if there's no body, it's just like, I wonder how we did it and got away with it. Like, there's landlines and no GPS. Now, everyone can find where I am. It would be the camera, the iPad, he was on some sort of tracker, wasn't a GPS through the federal probation system, but it was like some sort of tracker, cell phones, cars, they can find you anywhere. So it's a different kind of case than when we say like, oh, it's no body, it's difficult. Yeah, it's difficult, but not as difficult as it used to be. So I think it's going to be an interesting one. I'm looking forward to opening statements tomorrow. The court starts at 9. I don't know if she'll get right out on the bench at 9, but I presume she'll be out there pretty early because they'll be getting the jury in. Another issue, that Judge Fournier basically told the jurors about no social media, no news coverage. And it's difficult. I have to tell you, I really do have to tell you that I don't know what we're going to do in the criminal justice system to sort of like take social media and take the media out of it. But I do think it's going to be a problem moving forward in terms of like getting a fair and impartial jury. I just really do. I think it's really difficult to say like no social media or no news. It's like should I not go on my phone? Am I not supposed to be on my phone for 3 weeks? And then how many people are actually following that? It used to be like, don't read the newspaper. And it's like, okay, most people didn't get the newspaper delivered to their door. And then it's like, okay, don't pick it up at the store and maybe don't watch the news at 5 o'clock. And then that's it. And you could avoid it, essentially. But now it's like, well, everything is inundated. It's in our faces. So it's going to be interesting to see how it goes. They expect the trial to last approximately 3 weeks, so leading right up to Christmas. I'm going to be covering it daily. So if you guys want to know what I'm doing, what we did with the Karen Reed case, which I think you'll like, is I have a chat that goes live every day on the morning of the trial. So starting tomorrow morning, I'll probably do it at like 8:45, launch at 8:30, 8:45 on Substack. So it's Note My Objection on Substack. And basically what I do there is for my premium subscribers, I release my episodes early. We're going to be starting back up on the lives, particularly, when we have stuff to talk about the Walsh case. And then we have a chat. I'm going to keep the chat open for everybody because I think it's a good way to, have real conversation. The best thing about my Karen Reed chat was like there were people from different perspectives. And towards the end, people started getting, but I love the people who are in my community have different positions, different perspectives, and we're still able to like have real conversations. And we always talked about like the substance of the case as opposed to like the drama of the case. So if you want drama-free legal coverage, like, it's a good place and there's good people. So go over to Substack. We'll be doing lives, and then I'm going to be doing YouTube every night. So I won't have a set time because I have kids' schedules and dinners and real world stuff. I got a mediation on Tuesday, so we're fitting all of this in. But I'll have a nightly breakdown of kind of like what the testimony was, what happened. It might just be between, 10 and 20 minutes, 30 minutes every night. And then I'm going to try to do lives in between. So everywhere I am, make sure you follow me, share, like, subscribe, comment. It really, really helps the algorithm. And otherwise, I hope you guys have a fabulous Sunday night, and I'll see you tomorrow.
If you like this episode, please comment, like, share, and subscribe. Every bit helps. Thanks for watching Note My Objection. See you next week.